A very hearty good evening to all of you. Yesterday I recorded the same lecture, but I don't know what happened. I suppose some because of some technical glitch, the PPT is not apparent, is not visible. And then again, I thought that I should I should provide a brief note on whatever we have seen because it is necessary to continue the link which is coming, to follow the link which is there. So now in the series, the last class, we have seen Karta's responsibility and liabilities, power of Karta in the joint family. So we have seen the power of alienation. How can a Karta alienate the property? As I told you, the alienation of property simply means transfer of property. And transfer of property can be made by gift sales and mortgages. So there are different aspects of Karta by which a Karta may alienate the property without seeking the permission, without seeking the consent of the co-partners. Okay, so further, what we have seen in the last class, there are three important aspects of power of alienation of Karta, which are legal necessity, benefit of the states, and indispensable duties. So this was the last thing which we have discussed in our last class. Now, moving to the next slide, we have seen in what is meant by Karta power to contract debts. The Karta has an implied authority to contract debt and pledges the credit of the family for ordinary purpose of family business such that incurred in ordinary course of business are binding on the entire family. So all the family members are solely responsible of the debts which is made by the Karta. And we can say that the Karta of non-business joint family also has the power to contract debts for family purposes. Such debts are binding on the family members of joint family. Also, when a Karta seeks a family liability for such debts, it is necessary for him to prove that the loan was taken for family purposes or in the ordinary courses of business, or that he made the proper and bona fide inquiry into the existence of need. Okay, the expression purpose has almost, you can say, the same meaning as legal necessity and benefit of state or performance of indispensable and pious duties. Just an alienation, you can say as an alienation which is justified for legal proceedings, a debt is also justified for the same purposes. Now coming the power to compromise. When we talk about power to compromise, I would like to give a brief introduction because in the bracket you are able to see Order 32, Rule 7 of CPC. Civil Procedure Code is a procedural law which supplements the substantial law, which is family law or Hindu law. So there are two laws, substantive law and procedural law. So when we talk about family law, it talks about rights and liabilities, whereas Civil Procedure Code is a supplement law which tells us about the procedural part, how you have to infuse the suit, how you will bring the suit, how you will ask for the remedy, what are the rules related with it. And when we talk about CPC means Civil Procedure Code. It is a Civil Procedure Code of 1908. It was enforced in the year 1909. A very old, you can say, and there are certain amendments have been made to keep it with the time and post independence also, but it is a very complete and exhaustive code in the sense that it suffices the cause of civil proceedings. This particular civil procedure code you will read in your ninth semester. You will study in your ninth semester, It is further divided into two parts. First is sections, and second are orders. Section tells us about the provisions and order here. O means order, and order are the supplementary parts which tells us about the procedural part. So whenever a suit is instituted, you have to draft an application, and that application is known as a plaint because the plaintiff is bringing it, the party who is asking for a relief, and the against whom the relief is being sought out or asked is known as defendant, and his we can say his answer to the plaint is known as written statement. So this is the basic difference between a plaint and a written statement. As you are dealing with law, law has its own matrix which says that a lawyer should know, or a student of law should know everything of something and something of everything. So you should have a certain understanding what is going on, what law is talking about, and how civil procedure codes help us to identify how civil procedure codes tells us about the procedural part, what is the important part regarding the institution of a suit. So in that particular civil procedure code, there is a provision which tells us about regarding the minor, the power to compromise. The Karta has power to compromise all disputes relating to family property. And when the Karta is engaged with the management of family property, he can compromise a suit pending in the court, and it will be binding on all the members, though a minor co-partner may take advantage of Order 32 Rule 7 here. Because it is assumed that the minor is a person who doesn't understand the worldly, we can say, affairs, and therefore Order 32 Rule 7 lays down that in case of the party to a suit, if a party is a minor, the compromise must be approved by the court. You have to bring that particular compromise to the court of law if a person is minor. Also, we have seen the same thing in contract in the case of Mohri Bibi versus Dharamdas Ghosh. If you are able to recall the same thing, the same logic applies there also. That all the contracts which are committed or made with a minor are void by nature. So same rules apply here, that in law minor has been provided certain exemption, not only law of contract or family law, but also in the Indian Penal Code, which you will be studying in your upcoming semesters. So he can compromise family debts, the Karta can compromise the family debt and other transactions. However, if this act of compromise is not bona fide, it can be challenged in a partition. Okay. The Karta has no right to give up substantial portion of a debt due to the family members out of charity or sympathy with the debtors. So Karta is also having certain limitations which Mr. Karta need to follow. He is not in a position that his powers are absolute. If he has done something, if he has done some sort of compromise which the other co-partners feel that that the particular compromise is not genuine enough, it is having some sort of we can say fraud or some sort of irregularity. So that particular compromise can be challenged in a partition, and the Karta has no right to give up a substantial portion of debt due to the family merely out of charity. The Karta is not the person who the family member has chosen that he will be doing charity or sympathy with the debtors. So Karta are also having, we can say, a liability towards the family members. Now coming to the next important, we can say, power of the Karta. The Karta has the power of a joint family, takes a loan or executes a promissory note for the family purpose or family business. So what is a promissory note? A promissory note is something which Karta or any individual who is making it, he is doing a promise that he will pay the particular amount or particular sum to the party. This particular promissory note is further defined under the Negotiable Instrument of 1881. Negotiable Instrument of 1881, it is a separate act which has been created for all the transactions related with promissory note, checks, and so on. So that particular thing is defined under the negotiable instrument of 1881. So Karta of a joint family, whenever he takes a loan or executes a promissory note for family purpose or for family business, the other members of the family may be sued on the note itself. Even if they are not parties to the note, their liabilities are limited to their share in the joint family property. Though the Karta is personally liable on the note. There is a difference of opinion among the high courts regarding the promissory note. Some of the high courts are having the opinion that the co-partners are liable on the note itself, or whether their liability arises out of the debt. So there is a, we can say, difference of opinions of the Allahabad High Court, the Patna High Court, the Nagpur bench are having the, we can say, view that that the liability arises out of debt. If there is a debt, you have to pay for it. And the, we can say, the Calcutta and the Bombay High Court, the Calcutta and the Bombay High Court are having the opinion that whether there is a liability which arises out of a debt. This is the view of the Bombay and the Calcutta High Court, and the Nagpur and Patna and Allahabad bench are having the view that the co-partners are liable on the note itself. So there are difference of opinion regarding particular thing, and it is a very, we can say, technical aspect of the business, or we can say business laws regarding debt and liability on the note. So whether the Karta is liable or the family members are liable, there is a difference of opinion. The distinction between liability on the note and the liability on the debt is very material. Okay, if liability is on the note, the consideration in certain circumstances will be presumed. So the court always has to presume something. When you will read law of evidence in your seventh semester, you will find out that court, there are certain circumstances in which the court presumes until it is rebutted. So there are two, we can say, presumption in the court. In law of evidence, may presume and shall presume. When we talk about may presume, what does it mean? And when we talk about shall presume, what does it connotes? Shall presume is a very strong presumption until unless it is rebutted. The court will assume the same thing. May presume is something which can be rebutted very easily. For example, when we talk about certain, say certain currency or certain document, official documents of the government of India, the court may infer from such documents that it is presumed and it is shall presume. So here what is going on? If the liability is on the note, the consideration in certain circumstances will be presumed. While if the liability is on the debt, it will be necessary to prove that the debt was taken for the purpose binding on the family. If there is a debt, it has to be further proved that the debt was taken for a purpose binding on the family, and which we can say the same thing has been taken by the, we can say the same thing has been accepted by the Calcutta and the Bombay High Court. Okay, when we are talking about the presumption that a debt was taken for the purpose which is binding on the family. And when a promissory note is in favor of the Karta and his sons, the Karta alone can sue on the note for the recovery of the debt. So these are the minor, you can say, powers of the Karta, and liability also shifts. Whenever the Karta is having or making or drawing a, you can say, promissory note, so it has to be ascertained that for which purpose that particular note was drawn in, the loan was taken. So these are the, we can say, these are the essential parts of the Karta, which I tried to discuss with you. Now we are moving to the next topic, the topic which you missed and for which I asked, for which I have already shared a PPT with you, which talks about obstructed and unobstructed property. So unobstructed heritage or unobstructed property. In Sanskrit, it is known as aprati bandha daya, and obstructed sarvati bandha daya. As the name suggests, obstructed, it means that there are certain obstruction to the property. There are certain obstruction to the, we can say, to the property. And unobstructed property means that there is no such obstruction. Okay, the property is free. Whenever you see in the Takshara, the co-partner, the male co-partner used to have a birthright in the property, which means when the moment the child has born, he is having certain rights on the property. This is known as unobstructed property because there is no obstruction. The property is free. On the other hand, if the property is gifted by a will, and the property is transferred by a will, and it depends upon the creator of that will or testimony. What happens? Suppose we all know that the rule is that only the last will be accepted. Last will be accepted in the court of law because there is a it depends upon the mood and upon the whatever upon the behavior or on the perception of the will maker. If he's having this particular perception that no, I want to change my will, so he's free. If today he has made a will, tomorrow he can change it. No law, you can say, stops that particular thing. So this particular property which is being made by a gift or by a will, it is something which is obstructed until the particular person who's making or drawing the will, he is alive. That's why it is known as obstructed property or obstructed heritage. Now we will be discussing this particular two concepts in details. Okay. Now moving to the next slide. Okay, when we talk about unobstructed heritage, ancestral property is known as unobstructed heritage. Okay, whereas obstructed heritage is a property inherited by a Hindu from a person other than his father, grandfather, or great grandfather. Okay, so the property is being given out of love or affection. That is obstructed property because it depends on the third person. And unobstructed heritage or unobstructed property is a property which is coming directly, we can say, from the first particular person. The essential feature of unobstructed heritage according to Mikashara law is that the sons, grandsons, and the great grandsons acquire and inherit in the property by birth. This particular point is very important. We have already seen this particular aspect of birth and see what consequences it is taking or carrying with it, and how and what impact it is having, and how long we can say lasting effect it is carrying. Because what is meant that it is called obstructed because the accrual of the right it is obstructed by the existence of the owner, and the owner is the person. The owner is the person. We can say that he is having a mood. He is having what we can call frame, a bent of mind, whether he's willing to further alienate that property, further transfer the property in whatever means of gifts or we can say affection. So it is known as obstructed heritage. Okay. Now moving to the next slide. The right attached to by their birth, the property is called unobstructed because the accrual of the right is not obstructed by the existence of the owner. Are you able to get it? What I'm trying to say? Okay. So it means that the right attached to it by the birth, the property is called unobstructed because the accrual of the right to it is not obstructed by the existence of the owner. Whether the owner is there or not, it doesn't create anything because the right is being transferred by the, we can say by the birth. Is it clear? Okay. So on the other hand, when we talk about the obstructed property, what does it mean? What does it connote? The owner holds it as his separate and absolute property. Okay. The relation of the owner do not take a vested interest by birth. They are entitled to it only on the death of the owner. Thus, the property which devolves on parents, brothers, uncle, nephew, or the death of the last owner is known as obstructed heritage. This is the major difference. Okay. Now we're talking about survivorship. So the unobstructed property devolves by survivorship. The concept of survivorship we have dealt in length. What is meant by the survivorship when the partner, when the co-partner used to die, what was, how this particular property was distributed or alienated among the existing co-partners, and how the notional concept of notional, you can say, partition used to happen. Whereas on the other hand, when we talk about the obstructed property, this property comes by the mere inheritance. Okay, these are the basic, we can say, differences. Now further we will understand the concept with the help of an example. In unobstructed property, suppose if A inherits property from his father or grandfather or great grandfather, and it is an ancestral property or unobstructed heritage in the hands of A as regard of the male issue, because of the existence of A and obstruction to his son acquiring an interest, but as regards other relations, he hold it as an absolute property. Okay, the same thing. On the other hand, when we talk about obstructed heritage, what happens? A inherits certain property from his brother. A has a son B. The property is obstructed in the lifetime of A. B does not take interest in it during the lifetime of A. After A's death, B will take it as A is higher by succession. The existence of A is an obstruction of the accrual to any right in the property to B. On the other hand, when we talk about unobstructed heritage, what does it connote? If A has got no male issue, other relation has no interest in the property during the lifetime of A. Okay, so now we can sum up. The property in which a person acquires an interest by birth is called unobstructed heritage. First point. Okay, it is so called because the accrual of right to such property has no obstruction. The property just freely passes without any hindrance or any barrier. Okay, this property inherited by a Hindu from his father's father's or father's father's father is unobstructed heritage as regards his own children, grandchildren, and great grandchildren. Their right to such property arises from the mere fact of their birth in the family, and as soon as they are born, they become co-partner of such property along with their paternal ancestor. Ancestral property, therefore, is unobstructed heritage. So this is something, this particular point and the point which we discussed in the first point, this point. These 2 points very clearly they distinguish between the obstructed and unobstructed property. On one hand, the interest is acquired by a person by birth, and in the other, it is known as all the ancestral property when it is being given or been, we can say, alienated, they are considered as unobstructed heritage. Okay, now moving to the next slide. Again, if you can say X inherits the property from his father and the son, Y is afterwards born to him. Y becomes a co-partner with his father X from the moment of his birth and therefore becomes entitled to an equal undivided half share in such property. Okay, if suppose Mr. X is receiving the property from his father and Mr. X, a son Y is born. So this Mr. Y, who has just born, who is an infant, becomes a co-partner with his father the moment he has been born and becomes entitled to an equal undivided share in such property. The property in the hands of X is unobstructed heritage because the existence of X is no obstruction to Y acquiring an interest in the property. So the property in the hand of X is unobstructed because the moment his child, the moment to X Y is born, Y also is having the same right in the property, and there is no obstruction. This is important. If, however, the right to property accrues not by birth, but on the death of last owner, that property is called obstructed heritage. This one. It is not by birth, but by the last. The same thing which we have explained and we have seen, we are just trying to sum up. Okay, so this particular property means obstructed heritage. So moving to the next slide. Why it is so called? Because the accrual of the right to such property is obstructed by the existence of the owner. It is obstructed because the owner of the property is still alive, he is in existence. Thus property which devolves upon parents, brothers, nephews, uncle upon the death of the last owner is obstructed heritage. These relatives do not take any vested interest in the property by birth. There is no such interest in the property which passes by birth. Their right to such property arises for the first time when the owner of property dies. Okay, as soon as the owner dies, the right in the property arises. Whereas when we talk about unobstructed property, the right in the property arises as soon as a particular child or a person is born. Until that time, that have mere succession, a bare chance of succession to such property, which would be realized only if they live longer than the owner of the property. Okay, so this is meant by the term which we say that obstructed and unobstructed property. The most important distinction between obstructed and unobstructed property is that unobstructed property devolves by survivorship, whereas obstructed property devolves by succession. However, there are 4 cases in which obstructed heritage also pass by survivorship. These are certain exceptions and not the rule. So here also survivorship happens when 2 or more children, grandchildren or great-grandchildren who are living as a member of a joint family succeed as a heir to the separate or self-acquired property of their paternal ancestor, take the property as a joint tenant with the right of survivorship. Okay, this will be we will be discussing in length when we will be studying rather the law of succession. So don't get confused at that particular point of time also, and in our next module, which is right of alienation. So here it is saying that there are 4 rules to obstructed property when 2 or more children, grandchildren or great grandchildren who are living as a member of joint family. They are the part of the joint family and are succeeding as higher to the separate property. So they are succeeding to a separate property and not to the joint family property. So in this particular sense, what happened? They take the property as joint tenant because they are two or more than 2. Okay. So what happened? Then the rule of survivorship will come into motion because they are becoming as a joint tenants. They have been clubbed together. 2 or more grandchildren by a daughter who are living as a member of joint family, succeeding as a heir to the maternal grandfather, take the property as joint tenant with the right of survivorship. Now here it is talking about the daughter, and the case is saying that they are succeeding, 2 or more grandchildren are succeeding to their maternal grandfather, that is the father of their mother, and they take the property as joint tenants. So again, the right of survivorship used to come. Okay. Further, obstructed heritage devolves by succession, except in the following cases. This is the case which we have discussed. 2 or more widows succeeding to the heirs to the husband, which is take as a joint tenants and with the right of survivorship. There are 2 or more widows. So this is something which we used to practice. Don't get confused. All the law which is we are studying, we are reading or studying rather the law as the law is. Okay, there is no such thing. We can say that we are studying in segregation or watertight compartment post independence or post 2005. No. So there were certain practices, as I told you, prior 1955. There was bigamy was allowed in Hindu law. Okay, it was after 1955 that the bigamy was prohibited. So 2 or more daughters succeeding to the fathers as a joint, but in Bombay state they take absolute estate in severalty. So they get as an absolute estate in the state of Bombay, where they are having the absolute ownership and not as a joint tenants. Okay. So Mitakshara law, the distinction between obstructed and unobstructed, but under Daya Bhaga law, every kind of heritage is obstructed. So in Metakshara, we are having this particular distinction of obstructed property and unobstructed property. But in Daya Bhaga, there is every property is recognized as obstructed property in Daya Bhaga. Okay? Because according to Bengal school, no person at all acquires any interest by birth in the property of another, and merely the rule of survivorship does not apply to this school. So this was we have seen. Further, what more I can try to tell you that we have already discussed what is meant by separate property, what is separate property and what it is not, which is acquired by the effort of a particular individual. The term property does not specify means property inheritable by Hindus. It includes both movable and immovable property. So this was something which I was willing to give you or rather provide you as a note which you people missed. Okay. So from the next, we can say from the next lecture, I will start to give a brief introduction of self-acquired property, and further we will be moving to our next, we can say, new topic which is there. So I hope that everything is fine at your end. I would like to end up now because today I was not able to get time. I was busy. There was a meeting which was conducted with the Honorable Vice Chancellor. For we were there for 2 hours, and then there were certain works of APC, the Academic Planning Committee, and for which we are working for the Supplementary Exams Act, and we have to schedule the timings and the dates of the respective panels who will be sitting on it. So I would like to end up today. In the next lecture, we will continue from self-acquired property. Thank you and for your patient listening and watching the lecture. I hope that you are making your notes also. And after some time, again, I will be providing you the notes of the concepts which we are dealing with. Thank you.